Hi, my name is Janet Morales and I would like to discuss today the ethics of Anti-Piracy Acts and privacy. Over the past several years, the Internet has become a vital archive of information that has enabled communications and research possible on a level that was never before achievable. However, with this proverbial great power has come also an incredible deal of responsibility, which has manifested through various institutions as regulatory processes and legislations that shape the format of Internet access in the United States and indeed even worldwide. Two such acts are the Stop Online Piracy Act, also known as SOPA, and the Protect IP Act, also known as PIPA. These acts are both supported and condemned by various perspectives, many of which applaud the intentions of the legislations, though they also acknowledge the potential negative impact. To give a little bit of a background, media distribution companies have attempted numerous methods for many years to dissuade consumers from pirating, including enlisting the aid of internet service providers to block websites that feature such content, working with government agencies to shut down said websites, and even directly suing consumers who they determine to violate intellectual property laws. However, these acts do not account for overseas websites that feature U.S. content hosted in remote locations, such as in the case of the piratebabe.org. Being a $7.7 trillion industry, there is a strong legitimate interest in protecting the economic stability of the U.S. entertainment industry. The two acts reviewed here are responses initiated by different facets of the U.S. government to address piracy and are intended to protect the work of creative artists and major entertainment conglomerates alike. Enacted by the U.S. House of Representatives, this bill is aimed at foreign websites that infringe upon copyrighted material and essentially grants the U.S. Attorney General the power to require internet service providers to take technically feasible and reasonable action to prevent end-user consumers from reaching offending websites. Here may be seen the first clear indications of ethical privacy concerns. Americans, in particular, often seem especially sensitive to censorship, and this bill seeks to impose censorship upon users who are paying for access to a service. There are many examples in favor of and against this. For example, television is a common medium that users generally pay more for than they pay for the internet. However, television is also heavily regulated and censored, so to this extent, there is a present argument that suggests that just limiting the available options will not defeat the medium by any means. A sort of counterpart to the SOPA, this bill, which was introduced by the U.S. Senate, essentially serves the same function as the SOPA, but tends to be more specific in its requirement. For instance, SOPA targets any website in general that contributes to copyright infringement. PIPA's scope is more reserved for those websites whose sole function is to provide copyright infringing content, whereas SOPA can realistically impose action upon a website simply for even providing a tool that could facilitate copyright infringement. PIPA's legislation is more ethically feasible from a perspective of privacy concern, since it does not propose to block content that might not be exclusively dedicated to illegally distributing copyrighted materials. However, there is still the ever-present concern that by blocking specific types of content, the privacy and freedoms of the public are being impinged upon. Furthermore, there is no clearly defined public interest that would prevent PIPA from adopting a similar scope to SOPA. Incidentally, although both of these legislative acts were highly similar in function and were held, at least in some parts, by their respective sponsors to be an appropriate response to the problems that result from the free distribution available on the internet, unfortunately, many people do not seem to react that way in response to its effect on their privacy. The methods by which these bills effectively enforce copyright law are considered widely ineffective for their purposes, yet at the same time are also held as detrimental to society for their seemingly arbitrary enforcement criteria and their limiting effect on the internet application. Additionally, although the bills are not strictly partisan in nature, Stephanie Condon of CBS News determines that they are essentially a case of young versus old. The idea that the conflict regarding intellectual property and copyright laws is based on interpretation between generations is an accurate reflection of how disparate the viewpoints are. On the one hand, there are government officials attempting to represent the older perspective that seeks to execute legislation about copyright laws without having a clear indication of what exactly constitutes the ideas that they are defending. Thus, these government officials are attempting to fulfill their ethical duty of regulating an imminent public service. However, they lack understanding about the creative implications that the regulations would impose on the internet, and so many people consider their legislations to be unethical. On the other hand, there are major entities and institutions that exist primarily on the internet that could be affected by the lack of insight surrounding these two bills. What we see in various attempts by many organizations to combat piracy is an attempt for these organizations to define themselves as having a central interest in protecting the artistic creation of the people they represent. But at the same time, it seems that we do not ever hear from people actually involved in the creation process itself, but rather from those whose jobs have been to specifically protect these defined interests. This has inspired the ethical dilemma of whether or not freely downloading content constitutes stealing from the artist that created the content. Even though some artists have famously spoken up in the past against the free distribution of their materials, it is becoming increasingly harder to consider this is a relevant viewpoint in an increasingly digital world. Even though the legislations allegedly were created to reinforce the intellectual property rights of others, it seems that the public has been more or less unaware of the severity of the situation. This is indicated by the suggestion of Jafid Lev Aretz in the fall 2013 edition of the Harvard Journal of Law and Technology, when he claims that millions of people simply woke up to discover that the internet was verifiable after not being able to access Wikipedia. Here arises another ethical issue. Specifically, how can the intellectual copyrights of others effectively be defended from piracy if the general public is not even aware or perhaps does not even acknowledge that the proposed issue is even a problem? If legislators are ethically obligated to protect our freedoms, then should they not be equally obligated to ensure that the problem is one that has realistically detrimental impact on the public interest? Indeed, this seems to be a conundrum that some are still having difficulty answering, as the interest of these attempts to prevent online piracy currently largely results in protecting the interests of major production companies and entertainment networks. This is a precept that legislation such as SOPA and PIPA have failed to recognize, instead attempting to implicate an innovative distribution medium with traits of more conventional markets. So despite the goodness of their intentions, anti-copyright infringement agencies are actually helping to make the internet less effective as a distribution medium, in addition to inspiring counter-official technologies like the tools developed to break the previously prospective domain banning feature of the two acts. As long as the issue represents a division between the young and old, the newer, more innovative, technology-oriented people will always remain steps ahead of the copyright enforcement crowd. Unfortunately, this will not prevent copyright champions from continuing to promote and pursue their cause. It does indicate a distinct notion that separates the two groups. Those who fight copyright enforcement often do it more out of passion for the thing in question rather than illicit attempts to make money, which seems to be the understanding of pro-SOPA PIPA attitudes. Whereas those who fight for copyright protections tend to view themselves as the victims, despite utilizing the interests of the artists they represent. In the end, especially in ethical consideration, it seems more than just a cliché to suggest that love will always win.